We're going to speak now about the third of three Supreme Court Indian law decisions that we call the Marshall Trilogy. The first two I've talked about in other lectures. They are Johnson versus McIntosh, decided in 1823, and Cherokee Nation versus Georgia, decided in 1831. The case we're going to talk about now is Worcester versus Georgia, decided in 1832. So a little background reminder, Johnson versus McIntosh was the claim of a land speculation company to lands in the states of Illinois and Indiana that they claimed to have lawfully purchased from native peoples in 1773 and 1775. They lost on two counts, one being that their purchase was illegal under British law at the time. But then the second reason for which they lost, and it's the more important in the development of rights of indigenous peoples, was because of something that the Supreme Court established in American law and called the Discovery Doctrine. And the Discovery Doctrine is presented in Johnson versus McIntosh, provided that upon discovery of the New World, the discovering European sovereign, whichever it happened to be, instantly acquired ownership of the underlying title to all discovered lands, regardless of the fact that there were people already living there. The folks living there retained a right to occupy those lands, or an occupancy right in those lands, which turns out is fairly extensive. And they could alienate or transfer or sell or give that occupancy right, but only to the same discovering sovereign. We can think of those as, if we're categorizing as the vesting of fee title portion of the Discovery Doctrine and the restraint on alienation portion, which we might also call the preemption portion. It's a different way of saying the same thing. A preemption right in real estate is an exclusive right to purchase something if somebody should decide to sell it. It's like a right of first refusal, except you're the only potential purchaser. So in that second part of the Discovery Doctrine, the discovering sovereign was recognized to possess a preemption right to the occupancy right. So those are the two halves of Johnson. Now, as I've argued elsewhere, I think that Johnson was intended to resolve the land company's claims and some militia bounty lands claims in southwestern Kentucky and then disappear. But it didn't, because the Georgians found it. And Georgia saw that Johnson Discovery Doctrine as a useful device for ousting the Cherokee Nation, which had refused to enter into a treaty with the United States under which it would cede its lands in Georgia and move somewhere else. Georgia read the Discovery Doctrine as meaning that the British Crown, upon discovery of the lands that became Georgia, including those Cherokee lands they were interested in, had acquired ownership of the underlying title to the lands of the Cherokee Nation. And when Georgia declared independence, Georgia inherited the British Crown's ownership rights to those same lands, which meant that now in 1828, when Georgia's talking about this, Georgia owns the lands that the Cherokees live on. The Cherokees have an occupancy right, but Georgia owns the land, and that means, and this is how they phrased it at the time, Georgia's their landlord. And Georgia can change the terms of the lease if it wants them to leave. And so that's what the Georgia legislature does. It says, the Cherokees, you can stay here if you want to, but if you do, from the beginning of June 1830, you're going to be subject to Georgia law. And your laws will be of no effect, and you'll be divided up and attached to 4 Georgia counties. The Cherokees, not surprisingly, objected. They filed a lawsuit in the Supreme Court that the court took up in its 1831 term. It was a suit directed against Georgia, Cherokee Nation versus Georgia. Georgia declined to appear because they didn't think the court had jurisdiction to hear it. The court ultimately agreed. A majority of the justices said, you know, in order for us to be able to hear this case, to exercise what's called original jurisdiction over the case, which is to preside over a trial on these issues, we have to be satisfied that this is a suit, as argued here, between a state and a foreign state. Georgia's a state, and the Cherokee Nation, most of the judges agreed, is a state, but it's not a foreign state. Instead, Marshall said in his opinion in Cherokee Nation versus Georgia, it's a domestic dependent nation, whatever that means. Its relationship to the United States resembling that of a ward to his guardian. So the court has no jurisdiction to hear this, but come back. Cherokee Nation is invited by Chief Justice Marshall in a proper case with proper parties, and we'd be happy to hear your claim. So Georgia takes this invitation seriously. Georgia, I'm not sure that they really thought too much about it. Georgia declares Cherokee Nation versus Georgia, great victory for the state of Georgia, problem solved, and they start enforcing their laws in the Cherokee Nation fairly aggressively. Now, among the principal thorns in the side of the government of Georgia are New England missionaries who have relocated to Cherokee Nation, some under federal authority. For instance, one of them, the most famous Samuel Worcester, is the postmaster in the Cherokee Nation. So he's down there working for the federal government as well as for his religious organization. And Eliezer Butler is another. And these guys, as non-Cherokees in Cherokee Nation, are required under this newly imposed Georgia law to do a number of things, have a license from Georgia, to swear an oath of allegiance to the governor or to the state of Georgia among them. And they refuse to do both of those. So Georgia arrests them and tries them in a state court proceeding and sentences them to multiple years of hard labor. Worcester and Butler complain to the Supreme Court that they are being unlawfully held. And that's the case. That's the proper case with proper parties that Marshall was looking for. It's Worcester and Butler versus Georgia. We shorten it to Worcester versus Worcester versus Georgia. The court gets it in 1832. William Wirt is back to argue for the state of, or rather for the Cherokee Nation. And the court, unlike in Cherokee Nation versus Georgia, where the court split into three camps, the court actually comes together here. There is a majority opinion in Worcester versus Georgia. And then in that majority opinion, the Cherokee Nation will win. Now, it's best remembered Worcester versus Georgia, which is one of the early great pro-tribal rights opinions of the Supreme Court, primarily for the result and one of the two methods behind the decision. So the result is fairly clear. The court says Georgia cannot impose its laws over the Cherokee Nation, period. The state of Georgia has no legal authority to impose its laws on the Cherokee Nation. There's a bright line, in other words, jurisdictional line between the state and the nation, and the state of Georgia cannot cross it. Now, why is that the rule? Well, the reason that's best remembered is that for Georgia to exercise such power, which the court calls extraterritorial jurisdictional power, would violate the terms of federal treaty with the Cherokees. And under the Supremacy Clause of the Constitution, if there's a contradiction or inconsistency between a federal treaty or statute or the federal Constitution and a state statute, the federal treaty, statute, or the federal Constitution wins, period. And that's what happens here. So a big part of I think the best remembered part of the Worcester decision is Georgia can't do this because there's a Supremacy Clause problem. But there's a second part of the decision that I think for contemporaries was even more important. And it has to do with that Johnson discovery rule. The Supremacy Clause holding, realize, works for the Cherokees because they've got a treaty that has inconsistent provisions. But not every tribe has a treaty. And what the court has an opportunity to do here, Marshall's an enthusiast for the idea of using one case to resolve a whole mess of cases. What the court has the opportunity to do here is to take care of all those non-treaty tribes too. The Removal Act, or rather the Removal Act, which the federal Congress pushed through or passed in 1830, provided that if tribes want to, they can trade their lands that are within the bounds of existing states for federal territorial lands out west. The goal of the removal policy is for every tribe to do that. But what's the incentive? Well, the incentive is that if they don't, the state will impose its laws on them extraterritorially, and it'll be too uncomfortable to stay. Well, what do you do to protect, if you're opposed to that policy, as John Marshall clearly was, what do you do to protect tribes that don't have the benefit of the Supremacy Clause because there's an inconsistent treaty? And the answer is you pull the problem up by the root. What's the basis for Georgia's authority to impose its laws? It's the landlord. Well, why is it the landlord? Because in Johnson versus McIntosh, the Supreme Court said that the discovering sovereign acquired underlying fee title to the land. So we own the land, so we can change the rules. So what John Marshall has to do in order to forestall the possibility that another state will do that, will claim on the basis of its ownership of underlying land title the authority to impose its jurisdiction, if there's no treaty to protect the tribe, is to reverse that portion of the Johnson decision. This is politically complicated. John Marshall was nothing if not a savvy politician. He's the guy we credit with having turned the Supreme Court into an institutional powerhouse within the federal system, claims the power of judicial review, starts issuing majority opinions. The Supreme Court by the 1830s is a force to be reckoned with in a way that it wasn't in the 1790s. And Marshall doesn't want to jeopardize that. He's also alienated a lot of players in many states because after Marbury, the court, under Marshall's direction, went on a campaign of invalidating state statutes, just running down the map. New York bankruptcy law, unconstitutional. Georgia got hit. In the case of Fletcher versus Peck, they were the first in 1810 when they passed a statute repealing an earlier grant, and Marshall said, unconstitutional. Virginia outlawed a District of Columbia lottery ticket sale, unconstitutional. So he's alienated people who don't really see the court as being in the business of invalidating state legislation, the federal Supreme Court. So he's got to be careful here. If he reverses himself, he will confess error, and that's politically dangerous. So he's got to figure a way to reverse himself without letting people know that that's actually what he's doing. And the solution that he comes up with is to rewrite the Johnson opinion and represent the authority on which the Johnson decision was based without ever referencing Johnson versus McIntosh. The Johnson opinion was based on Marshall's reconstructed history of the colonial era, English charters for the most part. He had said in Johnson, granted effectively rights to ownership of title, and so that's the rule and we have to live with it. In Worcester versus Georgia, he returns to those same charters, but the history is radically different, and I'm going to quote from it. He says, and I'll tell you when I'm quoting, he says, or I'm saying, what was the intended legal consequence of the charters? Certainly not, and this is a quote from Marshall, the extravagant and absurd idea, leaving the quote, entertained by Georgia, quote, that the feeble settlements made on the seacoast or the companies under whom they were made acquired legitimate power by these charters to govern the people or occupy the lands from sea to sea. Off quote, this idea, quote, did not enter the mind of any man. So, okay, so what were they intended to do, or what was their legal consequence? And Marshall says that these charters were well understood to convey the title which, according to the common law of European sovereigns respecting America, they might rightfully convey, and no more. Well, what was that? This was the exclusive right of purchasing such lands as the natives were willing to sell. That's the preemption half of the discovery doctrine, but not the vesting of fee title half. Just in case you miss it, in the first instance, Marshall repeats it. The Crown could not be understood to grant what the Crown did not affect to claim, nor was it so understood. These grants asserted a title against Europeans only, that's we the English get to buy these lands and not you the French, and were considered, and these are his words, a blank paper so far as the rights of the natives were concerned. So, under the discovery doctrine as reformulated in Worcester, there is no vesting of fee title. Georgia isn't the landlord of the Cherokee Nation, and they have no basis for claiming the authority to exercise extraterritorial jurisdiction over them, even if there isn't a treaty that says that they can't do that under the Supremacy Clause. And the implication goes wider because the entire removal policy is dependent on states having the power to impose their laws on Indian nations within their borders. And what Marshall has said in this part of the Worcester decision is no state has that power because no state owns those lands. Now, this is an extraordinary opinion. It gets issued, published. Jackson receives a copy, and this is where Jackson allegedly, famously says, well, John Marshall has made his decision, now let him enforce it. And that's a tricky point. These two guys are still in jail in Georgia. And mechanically, what will happen is the Supreme Court is in recess over the summer. They'll reconvene for their next term. And then they, if they're still in jail, will have to issue a mandate to Georgia saying, let these folks out, at which point Georgia could say no. And that's their track record when the Supreme Court's communicated with them. So what happens then? Well, this could have become a great constitutional crisis, sort of the executive and legislative branches versus the judicial branch. It didn't, thanks to South Carolina nullifiers, because this was the summer when South Carolina, somewhat excited by the spectacle of the president supporting the state of Georgia against the Supreme Court, said, well, so we don't have to collect the tariff anymore, the federal tariff anymore, do we? Because President Jackson likes the states. So they convene the Nullification Convention, which is the subject of a different lecture in the series, and pass an ordinance that says South Carolina doesn't recognize the constitutionality of the federal tariff, and so we're not going to collect it anymore. This proves too much for Jackson. There's no way to tell what he would have done with Georgia had South Carolina sat quiet over the summer and fall of 1832. But nullification is too direct a challenge to the Union, so he jumps into the South Carolina situation, introduces the force bill, which eventually passes, which would have empowered him to send troops in, and communicates with the governor of Georgia, you let those missionaries out of jail, which on the last possible day, the day before the Supreme Court reconvened for its next term, the governor of Georgia did, releasing Worcester and Butler, reluctantly, but releasing Worcester and Butler. Now, where does this leave us on removal? Well, this is where the story again becomes, for a brief period, political. The Jackson administration was opposed to the Worcester versus Georgia decision, sent emissaries out to tell tribes that it actually wasn't correct. And they persuade enough tribes that that's true to get some tribes started executing removal treaties. The Chickasaws agree to remove, the Choctaws agree to remove. Other tribes, the Muskogee Creek agree to remove, and other tribes in the northern states agree to remove as well. The Cherokees don't. The Cherokees hold off because this is their decision, and they've been told that these laws can't be applied. So why would they agree to a removal treaty? And they might have been able to actually pull that off, but for the fact that that folks started dying. And the composition of the Supreme Court started to change. In 1836, John Marshall dies on July 6th. And some of you may know this, but at the service to commemorate his passing in Philadelphia, they decide to ring this giant old bell, and it cracks. It's the Liberty Bell. Two Justices, John McLean and Justice John McLean and Justice Henry Baldwin, had been named to the court by Andrew Jackson in 1832. In 1835, Jackson had put James Wayne on the court. And that same year, Gabriel Duvall resigned and John Marshall died. I said 1836, I meant 35. What that meant was that for the 1836 term, there were 5 justices and 3 of them were Jackson appointees. And that made possible a revisitation of the Johnson versus McIntosh discovery rule. From 1836, for the next 8 years, a majority of the Supreme Court would be Jackson appointees. And during that 8-year period, actually starting in Marshall's last term in 1835, the Supreme Court found the opportunity in 5 separate cases to reintroduce into American law the Johnson versus McIntosh formulation of the discovery doctrine. One of these cases had to do with riverbed in New Jersey. One was land titles, or 2 were land titles in Florida. And it almost seems gratuitous where it gets snuck in, but it's always some variant of, and of course, as everybody knows, when the Europeans arrived, they acquired ownership of the underlying fee title to all discovered lands. Cite Johnson versus McIntosh. Worcester isn't cited at all. That vanishes in these opinions issued by the Jackson justices. And by 1842, which is when the Second Seminole War ends, which finishes southeastern Indian removal, that's all the Trail of Tears periods as these tribes move out, the Johnson rule is hammered back into American case law. The Cherokees eventually recognize it's up, and a faction agrees to remove, and all of the other tribes do as well. That introduces another topic, of course, of U.S. history and history in Oklahoma. But as far as the case law is concerned, that resuscitation of the Johnson rule that the court had attempted to kill in the Worcester decision is still the law. It's a rule designed to shore up a long since repudiated federal policy, the policy of Indian removal. And it isn't the rule, in the end, drafted by our great Chief Justice, John Marshall, but rather by a series of Jackson appointees whose names most of us have long since forgotten. Thank you.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.